What if I told you that most people lose in court not because they're wrong, but because their paperwork wasn't ready? In this video, I'm going to show you how to get your discharge evidence organized for court, whether you're fighting credit card debt, traffic tickets, utility bills, or even foreclosure. This isn't a theory. What I'm going to be talking about is how I've helped people win using private remedy, consumer law, and administrative process, and I'll show you how to bring the receipts when it matters most. Now, before we dive into this video, thank you guys for watching this video. Thank you guys for tapping in. If you're brand new, hit the subscribe button, hit the like button, okay? Turn on those post notifications so that you can get an update every single time we post a video, all right? If you invest in me, I'll continue to invest in you. You dig what I'm saying? Another thing, this is not legal advice. This is not financial advice. These are just for educational purposes only. These are my findings from my research and my experience, okay? I'm not an attorney. Make sure you consult an attorney before you do any of these processes that I talk about on this channel. All right. The reason why we're going to be talking about putting together that evidence is because in order for you to actually get full remedy, you're going to have to learn how to put the evidence together and understand that your evidence is what's going to help you win. All right. I think that when it comes to debt discharge, we think that it's about the first letter. We think that it's about, these extravagant methods of discharge, a check, a coupon, some magic phrase, some magic lotion or potion. But the real magic is in the evidence. So what we're going to be talking about is how to put the evidence together, what evidence you should be making sure is in your evidence binder, and why you should be doing this. Okay, so stick around to the end of the video so that you can be able to get this game, understand the different categories that you need in order to fully win with your evidence, how to organize it properly, and how to execute. Okay, this will be a quick video, so stick around all the way to the end and hit the like button. Now let's dive straight in. Here's why it matters to have the evidence. Okay, number one, judges don't read intentions, they read documents. Okay, the reason why you may intend to be morally right, you may intend to get the justice that you need, but the reality is that the judge really doesn't want to talk about your feelings or your emotions. They just want to see cold, hard facts, solid truths. And if you can present these truths in written form, that makes your case that much easier. Okay? It makes it that much easier because instead of you going up there trying to explain your case, the paperwork is going to do the explanation for you. Okay? And all you have to do is just piggyback off of your paperwork. And it's not that you have to go and really explain what happened. Everything is going to be explained in the paperwork. All the truths and all the proofs are going to be put in the paperwork. So for example, if you ask specific questions in your paperwork over a period of time and it wasn't answered, that will also be revealed in your evidence as well. Okay? So it's best for you to have the documents throughout the process. It's best to have how they responded in instead of you trying to go up there with your sob story. Okay? Remember, the court they're gonna move based off of truths. They're not gonna move based off of how you feel. Okay, so we're gonna try our best to position ourselves to move with truth and honor, and not like based off of hoping for justice, hoping that the judge is gonna move morally. Okay, they're gonna move based off of procedures in business. Okay, you need a paper trail so that tells the story about your administrative remedy. The paper trail is gonna reveal everything that needs to be revealed. Okay. And it only will leave open. You really want to structure your evidence to where there really isn't much questions to be asked after that. Okay. And it's more of you enforcing the things on what you originally put together. Okay. Now, without evidence, the court assumes that you ignored, you didn't move in honor, and you're in default. But when you have communicated, if they come to the premise that you breached your contract, you can easily argue that you tried to communicate with my other person I contracted with about some of the terms and my concerns, and they ignored me. That right there in itself is a violation of contract law foundations. Okay, so if we pull up contract law foundations, okay, contract law foundations, okay, this is what's essential to contract law. offer, acceptance, consideration, mutual intent, which is the meeting of the minds, capacity, and legality. So if you're challenging the legality, if you're challenging whether there was a mutual intent, if you're challenging whether there was a consideration, okay, you're challenging the legality, if you're disputing it, okay, it shouldn't just be like ignored. Because if you are disputing a contract and you have evidence of it and they try to continue on as if you didn't dispute it, that right there is a violation of contract law within itself, okay? It even talks about dispute resolution. Contract law provides mechanisms for resolving disputes, including negotiation, mediation, and litigation, okay? So, and also contract performance. Contract law also addresses the execution and performance of contracts, including issues like breach of contract and remedies, okay? So if you had a question about how you should properly perform on this contract, then this is a dispute. This is a dispute that you're attempting to resolve. So if you're attempting to resolve, negotiate, mediate, or litigate a contract, then they should cease collection. If they're still trying to collect, then their breach of contract is based on them not being able to collect. That will be null and void with your evidence. I hope you guys gather that. All right. Proper discharge isn't just about what you sent, it's about what you recorded, notarized, and tracked. So you want to make sure you keep record of every single thing that you send to a debt collector. You want to make sure that you have record of every single thing that they sent you. You want to make sure that you have record of any certified mail receipts. You want to make sure you have record of any identifying data that can help your case. Okay? And these are the things that is important to the resolution process. Now, let's talk about the 5 categories of evidence that you need. The 5 categories of evidence that you need. Number 1 is the original contract or agreement, if available. Okay? The point is because you're going to show that lack of full disclosure. And you're going to use this to demand a wet ink signature, a certified copy of a wet ink signature. Okay? If it is a certified copy of a document, it's going to have some stamp, embossed symbol, or something, just like when you get your certified passport, your certified birth certificate, there's like a stamp on there that approve that that is a authenticated version, whether it was notarized or somebody witnessed it. Okay, it says a certified copy of a document is a authenticated duplicate of the original document verified by an authorized individual or entity as true and accurate representation. Okay, this verification provides assurance that the copy is legitimate and unaltered. Okay, it says a certified copy is not just a photocopy. It's accompanied by a certification, often a stamp, seal, or signature from an authorized individual or entity like a notary public, court clerk, or government agency. Okay, usually what they send you is a regular copy of something, a photocopy, and they don't have these embossed symbols on there or these stamps. So that's how you know something is certified. I spoke to an attorney. An attorney told me that, hey, well, the electronic signature or whatever the case may be, okay, bet. The electronic signature is fine. But show me the certified version of the original agreement or promissory notes, okay? So you want to have that contract. It's important for you to also review that contract and see where you can kind of pick them apart, where their lack of disclosure is, okay? And if they said that they loaned you money, then you can argue that too within the contract. So this is why you want to have the original contract, so you're not going in there lost and they're pulling up something that you never seen before. Number 2, any administrative notices. If you sent the conditional acceptance, debt validation, notice of fault, an opportunity to cure, cease and desist orders, notice of fault and dishonor, okay? Any other data that you have sent to the debt collector, collection agency, company, you want to make sure that you have all of your notices in your evidence binder, okay? Number 3, proof of tender or discharge, okay? Your remittance coupon, your bond or promissory notes, your IRS Form 1099A, 1099B, Form 56, 1099C, a UCC3 assignment or lien, any identifying data about your tender or you attempting to discharge or you attempting to perform on a contract should be in your evidence binder, okay? Number 4, tracking and delivery, the UPS certified mail receipt, the green cards or delivery confirmations, and notarized affidavits of service. You may not have all of these, but that's fine. Whatever you have, and these are all the things that you have used for the setup. When it comes to discharging debt, the most important factor is your evidence. Okay? How did you communicate? Did you communicate properly? Did you send a presentment? Were you clear and conspicuous about your demands? Okay? Were their responses insufficient or not sufficient enough? Did they provide evidence that you asked for? And all of this will be laid out in your evidence. Okay? It shouldn't be anything missed, because we're not going to go into court and we're going to be having a conversation about how I didn't pay, but I clearly asked you about this over the last 3 to 4 months and you decided to ignore it. Why did you decide to ignore it? Okay? Was that your intent? Would have a right to ask for it, right? So your evidence is what's going to pretty much now is shift the burden of proof onto them. And now they look like they have lacked performance according to the contract. Okay? So you also want to have proof that they ignored you, failed to rebut, or dishonored your notice. Okay? You want to have evidence of their silence, because in court, silence is considered dishonor under UCC 1-202 and UCC 3-603. I could pull that up right now, but we've covered that on this channel. Okay? UCC 3-603 literally breaks down the aspect of their silence can be assumed as a rejection. Okay? So if there is a rejection, okay, then there is discharge. Okay? And then UCC 1-202 talks about notice and knowledge. Okay? So a notice is pretty much like, for lack of a better term, it's right here. Has actual knowledge of it. Has received the notice or notification of it from all the facts and circumstances known to the person at the time in question. Okay? So the reason why you put them on notice is so that they have knowledge of it. And if you put them on notice about something, right, and you have clearly and conspicuously gave them notice, you clearly and conspicuously put them on notice about your tender, you clear and conspicuously put them on notice about your rights, you clear and conspicuously put them on notice about how the obligation will be discharged if they ignored it. You clearly and conspicuously put them on notice that if unrebutted, everything stands in truth. These things here is going to show up in the evidence. Oh, he clearly and conspicuously told you that if you did not reply, then this will be discharge. Why didn't you just reply? Okay? Someone would say, well, the judge would say, well, why didn't you just pay? Well, I'm going to ask the defendant, because I would be the plaintiff. I'm going to ask them, why didn't they just reply? Why didn't they just provide me the proofs? Why didn't they do their duty as a commercial entity? Why didn't they follow their regulations under UCC 9-210? Why didn't they follow the regulations under UCC 3, UCC 9? Because if it's a secure transaction or it's anything to do with a negotiable instrument, there are some regulations that regulate them and duties that they must adhere to. Okay? So again, they cannot just dishonor you, ignore you, especially when you have given them proper notice and knowledge. And if you didn't have knowledge of it, my evidence, if you say you never had knowledge of it, my evidence of my certified receipt and you signing off on it and saying that you received it is enough. Because contract law says, when you look at the postal rule, we can pull up the postal rule. The postal rule says that in contract law, also known as the mailbox rule, dictates that an acceptance of an offer is effective and a contract is formed when acceptance is posted, not when it is received by the offerer. This rule is a default in many jurisdictions and applies when the post is a reasonable or stipulated method of communication. When parties are communicating through mail or other method where the acceptance is not instantaneous, the postal rule states that the contract is formed when the acceptance is placed in the postal system. As soon as it's dropped in the mailbox, it is already accepted unless they send you a letter, unless the offerer, okay, or the offeree or whoever is receiving the offer decides to counteroffer that, okay? How would they counteroffer that? The only way they can is by literally sending mail back and offering it. And sending their counteroffer, okay? So that's why it's important to understand even just the simple foundations of contract law, because that is a part of it, and why, and this is what's going to enhance your argument. Okay? So they couldn't hit you with any BS like, well, why didn't you pay? Or not make it about their acceptance, their acquiesce, their silence. Because you gave them multiple opportunities to respond, and this is what's going to show up in the evidence. This is why the evidence is important. You can't go in there and say, well, I did this and did that, and you have no evidence of it. This is why you create a paper trail and you keep all your evidence. Okay? Even when it comes to the credit bureaus, if they are not responding, they fall under this as well. Okay? They also fall under a contract when you send them a notice for them to verify information and they decide to send you an update. If they just send you an update, that is not something that they could just say, oh, we sent them an update. No, I asked for written communication. Okay? And when I sent you the letter asking you to verify something, and the Fair Credit Reporting Act says that you must notate the procedures you took in order to verify the information. You can't just say something is verified. You have to provide proof of your verification, who verified it. And when you don't do that, you have just breached that contract, unless you sent me a letter back saying that you want to do that. Okay? But the thing is, the credit bureaus, they can't say that they can't do that because it's your information at the end of the day. Okay? So even though we're talking about debt, traffic, tickets, this, that, and the third, this also applies for the credit bureaus as well. Okay? If you get an update letter from Experian, Equifax, TransUnion that is not coming to your mailbox and is written form, and you can't physically pick it up and read it with your hands, and they sent it electronically without your consent. Like, if you sent the letter and you told them to write you back and they decide not to, this is evidence that cannot be overlooked in court. Okay? So now let's dive into how to properly organize this. Okay? First things first, you want to get you a binder, 3-ring binder. Take it back to the school days. You dig what I'm saying? You want to get you a 3-ring binder. If you can do this, tabs for each category above, whether it's a tab for the original contract, a tab for your administrative notice, a tab for your tender or discharge, a tab for your tracking or delivery, a tab for their responses or lack of responses. This is how you want to set out your binder, okay? You want to have page numbers and a table of contents. Any way that the better you organize this, the easier it is for them to be able to tell the story. Hey, I have evidence of this here. Boom. We're going to lay it out. And this is going to be even better for you so that you're not going into court trying to remember everything. It's already in your binder. And you could just go from tab 1 all the way to the end. Well, we responded, okay, well, here's this tab where I laid out your responses and these were your responses. I've never actually received whatever you're responding to me. Why didn't you tell me this before? You know what I mean? And this is why debt collectors and credit bureaus, they really fall short when it gets to small claims or arbitration and somebody is backed by evidence like this. Now, a credit card company or, other banking institutions, if you're going directly with them, they may you may need more ammo against them, but evidence is enough to parties that are, number one, third parties, or number two, they really have no standing to collect. The reason why I say that is because obviously you're going to need, a credit card company may be able to provide some type of wet ink signature or something like that. That may confuse you. But when you ask them simple questions like, did you securitize a loan? And they don't respond to that directly. Hey, look, I sent this letter on the 25th, and this is what they sent to me on the 5th of the following month. I asked them this on the 25th and they sent me this on the 5th. Why they didn't particularly respond to what I sent to them on the 25th, they decided to send this. So yes, they may have provided this, but they never answered this. You know what I mean? And if you have to create some level of journal or note taking of what's happening each day, that's something else that you can include in your binder as well. Okay? You can also add sticky notes or bookmarks to the pages to enhance your evidence even more, or know exactly what to say. If you have like a particular thing you want to talk about, you can literally take a sticky note and put it on the page so that you are now, you already have this. No one says that you can't pull up and look at your binder and read from your binder, you can do that. Okay? You also want to include the summary of a timeline and the remedy process. And this is all going to be laid out in your affidavit of truth and fault and dishonor. But if you don't have it, create like a quick little statement, summary, throw it in there, right? You can also put a glossary of the codes reference for your reference. You can put the UCC codes, the USC codes, the FDCP, etc. The Truth in Lending Act, whatever you feel like is notated in your process, contract law foundations, put a little glossary there, okay? Because this is evidence that's going to be submitted in the court. And your sworn affidavit of truth and record, okay? These are things that, again, it's going to put you in a position where you don't have to speak or plead your case as much because it'll be in the evidence. Even if you are there making it about you paying a bill, you can make it about them not doing their duty as it pertains to the contract, which is why you didn't pay. Again, this is a mediation. This is not a why didn't you pay? Give me a valid reason to pay. And if you give me a valid reason why you didn't pay, then you don't have to pay. No, this is a negotiation. So it's not just on you, especially when you initiate it like this. Also, another thing you want to take time to do, and this is what people overlook. If you're going to represent yourself in court, you need to come in there with confidence. Your evidence binder is going to give you the confidence because you're going to be able to tell the story. You having a glossary is important so that you can be able to review it for your reference and understand the legal merit behind your argument. But taking the time to present to yourself, look in the mirror, take your binder, look at the evidence, act as if you're talking to a judge, okay? Or an attorney, okay? Go through all the codes, like treat it like you're going to school and you're presenting. Some people may say, oh, presenting is scary or whatever the case may be. But sometimes you're going to have to pull that out your bag. You're going to have to get out your comfort zone to get the remedy that you want, if you truly want remedy. Someone say, well, I don't want to pay a bill, but they don't want to go the full distance. And this is why I tell people, if you're not willing to go the full distance, do these little steps, then don't do this, okay? But it's also not as hard as you think it is. It's just sometimes we get wrapped up in doing the same things over and over and over again. And some days we may need to deviate outside the box and do some work on this. Sometimes we may need to put our paperwork together, go back to the school days, literally sit down, get a binder, put it together, and be prepared to present like we're back in school again. Okay? Because if you present well, and you don't even have to have an A+, you can get a C or a D. You could do the bare minimum with your evidence. Okay? Some people think they got to go in there and talk like an attorney, but you really don't. Okay? And I'll tell you, if the attorney doesn't have much to stand on, they're going to keep it plain and simple. You know, this is not a criminal case. This is a civil case. And most times companies are underprepared because they don't know what to expect. Okay? They try to play you. They don't expect you to take them to court. So most times they're underprepared. Doesn't mean that attorney can't still win being underprepared. I mean, they're attorney, they get paid to do this. But if you're overprepared and you pretty much pull up the evidence and they have to go against your evidence versus what they say, then you are in a better position. So you want to go over what you sent, when you sent it, why you sent it, okay? You want to go over how they responded to each letter or failed to respond. You want to go over how the law supports your discharge, supports your claims, okay? So we could talk about UCC 3-603. We could talk about UCC 3-604. We could talk about the definition of discharge. We could talk about the definition of payment, okay? Payment means to discharge an obligation, and discharge means to nullify a contract, okay? All this is in a Black Law Dictionary. You can also refer to other UCC codes and things in that nature so that in the FDCPA and their duties and fully understanding. And it's not that you have to go up there and teach them anything. It's more for your reference, more for the record. So if one says, well, you can't do that, well, you have it there. Yes, I can because of this. How doesn't this apply to this? And it does apply. Okay? Now, if you do all this, evidence and all that, and let's just say that judge gives you a hard time, You can push for a continuance to get more evidence. You can do things like, if you do lose, you can appeal it and go to a different court or a different jurisdiction. You also can challenge the jurisdiction. I have a video talking about challenging the jurisdiction that will be in the playlist at the end. But at the end of the day, what's going to build confidence is your evidence. When you put in the work and you've sent the letters, you aren't the person who is not confident in court. Okay. Most times people are not confident is because they don't have the evidence. They didn't actually do the groundwork before they decided to go to court, or they gave up, or they don't have record of what's happening. And a lot of times, I'll talk to people and they'll say, well, I did this, that, and the third, and I'm stuck here. And I'm like, okay, well, that's how I can tell you're not like really controlling it. You're still moving with permission. In your letters at the bottom, you should say exactly what it is that you're going to do if they decide not to respond. If you decide not to respond, guess what? I will take it as acquiesce, and I'm going to assume that you have dishonored me. I'm going to assume that you're violating X, Y, and Z. I'm going to assume the debt is discharged. So now this forces them to actually give you a response. And if they don't give you a response, that right there is what's going to help you. If you put at the bottom of your letters that, hey, if you do not respond, this will be a discharge, and you bring that up in court and you bring up the fact that they didn't respond, now we're having a conversation about that. We're having a conversation about their acquiesce, okay? But this is only if you go in as the plaintiff. You have better chances if you go in as the plaintiff versus if you go in as the defendant. Because if you go in as the defendant, then you are just reacting. So you don't want to react. You want to be in position so that now they have to react to what you have sent them. And most times this leads to a settlement, okay? So the court typically respects what's on the record. The court typically respects someone who is organized and understands their case and is able to substantiate their claims and be able to unsubstantiate the other person's claims. Because discharge is about proof, not you arguing about morality, okay? Because discharge is not a moral thing, it's a commercial thing, all right? Treat it as such. So if you want to learn about this and learn how to put together the court-ready documents, if you want to get that binder checklist, tap into the school community. You can get a 7-day free trial so that you can be able to tap in and get that. You tap in, you say, dang, I actually like what's going on here. Stay tapped in, all right? This 7-day free trial is only limited for a short period of time, okay? Number 2, if you want to work with me one-on-one about fixing your credit, getting funding, tap into the mentorship link down below. That'll be in the description if you want to work with me one-on-one. Or shoot me a DM on Instagram, okay? Number 3, tap in with my Instagram, my YouTube, my Twitch, okay? If you tap into those platforms, that's how you're going to be able to connect with me on a more consistent basis other than 8:30 at night. And lastly, remember to hit the like button, hit the subscribe button, turn on the post notifications, and drop a comment. Let me know if you've ever gone to court, you didn't know to put together this evidence. Let me know your thoughts. If you have any other value that you want to give the community, drop it in the comment section down below. If you gotten this far, comment the word discharge, and I'll see you in the next one.